The attorney representing Young Thug in his RICO case, Brian Steele, was held in contempt of court by Judge Earl Glanville when he refused to identify who tipped him off to an ex parte meeting that transpired between the state, the judge, and star witness Kenneth Copeland and Copeland's attorney. The meeting allegedly involved whether or not Copeland was going to testify on the stand or whether he was going to invoke the Fifth. The fact that the rendezvous took place secretly is not the issue, but the fact that the defense wasn't immediately notified that an ex parte meeting occurred is. Now, an ex parte meeting is a legal proceeding where one party presents their case or request to the judge without the other party being present or even aware of the proceeding. It's generally reserved for urgent situations where waiting for the other party could cause irreparable harm to the case or when giving notice is not feasible. This is something that is typically reserved for emergency restraining orders or to resolve scheduling conflicts. Now, we do need to bear in mind this, that each state, each county, each judicial district inherently has their own set of specifications and regulations when it comes to ex parte meetings. And also, we need to keep in mind that Fulton County, Georgia, is notorious for having some pretty off-the-wall judicial rulings and case laws. They truly are in their own little world. What's known as the norm in most courtrooms is not the norm in Fulton County, Georgia courtrooms.
And what I found out is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment.
So can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation.
So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is why wasn't I there? Why,
sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not answering.
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
I tell you
what, I'm going to give you 5 minutes. If you don't tell me if you don't tell me who it is, I'm going to put you in, I'm going to put you in contempt. How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes. I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
The prosecutor on the case, Adrian Love, said there was nothing improper about what happened with this ex parte meeting in chambers regarding Kenneth Copeland being held in contempt.
We certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial.
Just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
And with criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. That I didn't ask or inquire about your alleged conversation for the court to be concerned about it. So.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty, 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia at 372.
Well, 1 second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215.
215.
Georgia app.
Georgia app.
372.
Okay.
Also 215. Georgia app. 349.
Okay.
That's Adams and Hasty.
All right, let me take a look at those. Do you have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older. And Judge, I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I've got space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their names.
They still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box and then there's room in the courtroom. So we would ask that they be allowed to.
I don't want them in my jury box, okay? No.
I understand.
Contempt is directed. Trial court has the power after confording the contempt door to opportunity to speak in his own behalf, announce punishment summarily and without further notice or hearing. I already did that, Mr. Steele. He's already told me. I already gave him the opportunity to do that. So we had that conversation this morning already. So
and Judge, there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. And as to how that information was disclosed, that's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does. I'm not saying anything, but you know, but he's kind of put himself in the particular position he's in.
No, Judge, I don't agree. I believe that
I'm going to disagree with you, okay?
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder or obstruct the orderly process of the administration of justice. The preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him just to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them, by nature.
Okay.
Okay, so this is absolutely amazing. I've said this many times.